U.S. citizens of the state of Ohio and abroad throughout this country. My name is Olakwesu El Bey, formerly known as Larry Ellis Ely. I became a free national here a couple of years ago after researching and studying that most minorities have been deprived of their constitutional rights under the 5th and 14th Amendments. We want to talk about several daily activities, mainly driving, traveling, traffic stop, the laws, the rules, who needs an operator's license and who has a right to travel. A lot of people are in dispute or don't understand what traveling means versus operating an automobile or a motor vehicle. A motor vehicle, you are required to have a state permit, which is an operator's license. The U.S. Supreme Court in Kent v. Doles, for all the people who don't understand what I mean, go to 357 U.S. 116 through 125. It states the 5th and 14th Amendment allows you to travel in your private automobile free of police harassment. You don't need an operator's license to travel in your automobile. Anybody want to challenge the U.S. Supreme Court, any judge, prosecutor, or citizen, feel free to send them a petition. What we have to understand is the law itself. The fact that you don't have a license is not the law. We have to understand who we are. We are free nationals. We are sovereigns. The U.S. Supreme Court affirmed, 37 states affirmed, you do not need an operator's license. You may get pulled over, you may get a ticket. But when you file your motion to suppress and your motion for discovery, and you file subpoenas, and subpoena ducis tecums under Civil Rule 45, the prosecutor and the police officers will begin to understand where you're going under common law. Before 1791, everything was common law. The 14th Amendment is just something that they made to create what they want to see happen, and then get us caught up in their web of not having a license or having insurance. We have a great deal of respect for public servants once they obey the law and don't break the law to enforce the law. We want to talk about also the writ of habeas corpus, the writ of mandamus, the precedendo, the writ of prohibition, quarento. These are special writs created by federal constitution and used in state courts as well. What we have here is understanding your laws and the nature of law and citing the law as it's written. When you go to court on a traffic violation, if you plead guilty or are found guilty under certain cases, the judgment may be arrested. C 2947.02, motion to arrest judgment. A judgment may be arrested by the court upon the motion of the defendant or upon the court's own motion for either of the following causes. The offense charged is not within the jurisdiction of the court, and B, the facts stated in the indictment or information do not constitute an offense. You also have to see the federal rules and criminal procedures as well. Rule 34, arrest of judgment. Normally, this has been expanded from 7 days to 14 days. The court on a motion of a defendant shall arrest the judgment if the indictment or information does not charge an offense of the court was without jurisdiction of the offense charged. The motion and arrest of judgment shall be made within 7 days, but I said now has been enlarged to 14 days. After the verdict of finding of guilty or after a plea. Keep that in mind, after a plea. If you plead guilty, you may arrest your own judgment under 33 and 34, 24, 29, 47.02. As I said, after a plea of guilty or nolo contendere, which is no contest, or within such further time as the court may fix it during the 7-day period. What we're dealing with here is most minorities don't understand the law, so they will continually be violated without due process. And we have to understand exactly what we up against out here, because apparently they not going away, and we don't expect them to go away no time soon. We are moving up towards a new decade, a new mecca and decade in law. Again, driving without license carried 30% of charges filed in American courts. We did an argument of law for Larry E. Ely himself. Recently was jailed for failure to appear on his driving without license. The argument of law there was the petitioner failed to appear, but he was never given a notice to appear. You must see 2937.99, Section D of this chapter, which is an ordinance confirming to this case where the contempt charge could not apply. Where operating a private automobile without a state permit is not a criminal offense found under 2937.99, as I stated, Section D of this chapter. What happened here in the Ely case was related to a motor vehicle located in the revised code under 4510. This section of the law sustains that the petitioner had been detained without due process. (2937-34). The petitioner had been detained where he has been, where no indictment has been found, but still being detained. This is where the writ of habeas corpus would challenge the bond or the illegal detention that you feel which is illegal. In the Ely case, he was not taken to a court to challenge the contempt. Under 2937-34, the sheriff or the facility respondent had a duty to take the defendant to the nearest court to be heard. Most of these cases fall back on another element, ineffective assistance of counsel. We find these kind of cases in criminal and civil cases where the lawyers just ain't doing their job. The Sixth Amendment guarantees you the right to effective assistance of counsel, not only counsel, and a right to a jury and a right to a speedy trial. Most minorities and African Americans are sitting in jail in violation of these statutes. Another very important statute in Ohio is 2945-71. You can see State v. Bowles. That's the time computation against your charge. Every day you sit in jail without being set for trial or trial being held counts as 3. Minor misdemeanors will be heard within 10 days of your incarceration, because every day counts as 3. What we have here is 2945-71 will override any charge based on time computation and a total of statute of limitations. You have to remember these statutes as you sit in jail and prepare your case. Even if you file a motion to continue trial or motion to suppress, each day still counts as 3 as long as you're sitting in jail. And when you're out, it's 1 for 1. They still got a time computation to eventually deal with. We want to go to, we want to talk about Section 1983, Title 42 U.S.C., 18 U.S.C. 242, 28 U.S.C. 141-41, which is a pattern and practice of conduct by police officers or officials which bears no statute of limitations because it's too found under the 5th and 14th Amendment and guarantees you the right to due process. As I stated before, most of these special writs can be used and executed through by way of the habeas and the mandamus, where a person is known to have a civil right violated or constitutional right or has been deprived equal protection of law. It's time for minorities to begin to exercise in this country the federal civil rights statutes pending from 1886, where the district courts were erected for African Americans only. Strada versus West Virginia was the first Civil Rights Removal Act under 28 U.S.C. 1441A, where an African American in West Virginia was charged with rape of a white woman, even though the white woman affirmed that this was not the man, and he still remained in jail. And this was the first case that did a state court removal from state court to federal court, where he was eventually discharged. And in Georgia versus Rachel was a 1964 case where 19 black Americans entered into a restaurant in Georgia and was asked to leave and then was arrested. And their cases were removed from state court to federal court under the diversity of citizenship laws. And it was dismissed. There's several cases out there that we must recognize. Some of the old cases to the current cases, to Graham versus Connor and Tennessee versus Garner, which were excessive force cases, which African Americans can use to adjudicate their civil rights in federal court. We have to continue to read and understand our laws each and every day, because the law is forever changing, and we have to change with the laws. Whatever God ordained you to do, you come through the Word of God, and you will be able to execute and exercise anything that you set out to do. I don't care where you come from or your educational background. They said I will always have a 6th grade education in 1974. I can rehearse and recite laws from the highest court in the land and can execute them on paper or in front of a jury. It takes practice, trial practice, and understand the law. As African Americans approach our new destiny, all the others will have to heed to the law review that we will bring to this country. And every other race or heritage will have to understand that African Americans are the original people ordained by God, the Most High. So what we have discussed here today is just a short session on civil rights and constitutional rights, due process. There is a way to execute each and every claim, each and every case through common law, because we have detected a defect in federal court when it comes to minorities. It's an ongoing defect and a permanent defect that must be eradicated by the Department of Justice and the U.S. Supreme Court. You must know how to execute your cases all the way to the highest court in the land, where it started out from the lowest court in the land. My website is Olakwesu El Bey. That's OLAKWESUELBEY@yahoo.com. Any further comments about what we discussed, anything you need to know about how to execute a case from inside a jail or outside a jail, from the outhouse to the White House, you can hit that website. We'll be glad as the Moors to discuss with you what you need to know and what you seek to do. Thank you very much.